Sorry about that. Colleen and I were on the Teams meeting link.
Not a problem, Commissioner. Glad to have you here. With that, we will get started. So good afternoon, everyone. Again, welcome to our second ever Debt Collection Advisory Committee hosted by the Department of Financial Protection and Innovation. My name is Suzanne Martindale. I am the Senior Deputy Commissioner over our new Consumer Financial Protection Division, which houses the Debt Collector Program. We greatly appreciate you joining us today. I will be facilitating the meeting for this afternoon. Before moving into introductions to the committee members and a run through the agenda and housekeeping items, it is my great privilege to introduce you all to our new commissioner, Chloe Hewlett, who just joined the department last week. She has some very brief remarks she'd like to provide. So with that, Commissioner, the floor is yours.
Oh, great. I'm very happy to be here. And I wanted really to take a moment to introduce myself, but I also wanted to acknowledge all the commitment and the work that you've done so far to really help our department to stand up as a new licensing program. And your feedback and insights from those that are truly on the ground are going to be very, very valuable as we move forward. I also want to thank Suzanne and Melinda for doing just an incredible job in spearheading this group. And as some of you may know, I am no stranger to state government in particular. I've actually worked under three governors, starting with Governor Jerry Brown in his first term. I hope that doesn't give away my age. And most recently, I served as Executive Director and Chief Legal Officer of the Cal Alumni Association for the University of California, Berkeley. And I've also worked as Director of Moral Character for the State Bar of California. So I'm very familiar with the whole area of licensing and the regulatory process, having had the responsibility of developing the process and procedures for admission to practice law in the state of California. And I see life through so many different prisms because I've also been a special prosecutions investigator, as well as assistant district attorney for the city and county of San Francisco, conducting high-level investigations, as well as prosecuting significant felonies. And to add to that, I have had extensive experience also in the corporate and business sector as a partner in national and international law firms, really helping my clients meet the challenges that one faces in the regulatory environment, as well as ensuring that they follow the law and know what it is. So I have a deep understanding of the work that the advisory committee is charged with and the importance and the impact it's going to have on all of us in California. So at this time, I really want to turn it back over to Suzanne and Melinda. And I really do appreciate the opportunity to introduce myself and to thank you for your commitment. And please feel free to call on me to give me your input, as well as any questions you may have of me. Now, I have to caveat that by saying this is my second week on the job, so I'm going to be learning a lot from you. So with that, Suzanne and Melinda.
Great. Thank you so much, Commissioner. We're all really glad that you're here. So now I am going to move us into remaining introductions, make sure that everyone in the public knows who our committee members are. So I will simply go based on who I see first in my Hollywood squares here. Prasad, would you like to introduce yourself first?
Hi, Prasad Krishnamurthy, a professor of law, UC Berkeley School of Law.
Thank you, Prasad. Elizabeth.
Hey everyone, I'm Elizabeth Gonzalez. I'm a staff attorney in the Consumer Rights and Economic Justice Project at Public Counsel in Los Angeles. It's a legal services organization.
Great, thank you. Next, Tamar.
Hi, I'm Tamar Udenfreund. I'm Senior Director of Public Policy at Encore Capital Group.
Thank you. Scott.
Yes, good afternoon. Thank you, Suzanne. My name's Scott Hyman. I'm a partner with Severson and Werson in Orange County, California.
Great. Cindy.
Hi, good afternoon, everybody. Cindy Yocklin, President and owner of States Recovery Systems and the former president for the California Association of Collectors.
Great. Mark.
Mark Naiman, president of Absolute Resolutions Corporation, a national debt buyer located in San Diego, founded in San Diego, as well as a previous president of the Receivables Management Association International.
All right. And Ohad.
Hi, everyone. Ohad Samet, CEO of True. Our subsidiary, True Accord Corp, is a nationally licensed digital-first, mobile-first collection agency. And our other subsidiary, True Life Solutions, offers our Engage product. It helps consumers choose who to work with in their repayment journey and other solutions that accelerate their ability as an on-ramp back into financial services. So very excited to be here today.
All right. Thank you to the committee and thank you for your willingness to serve a 2-year term to help us in these early startup days of building our new debt collector licensing program. So here's the agenda for today. It's going to be largely like what we covered last time. We will do a program update first. So Deputy Commissioner Melinda Lee will provide you with an update on how we're doing with building up the program and accepting applications. We will also ensure that there is time for committee members to ask questions of us about our progress in standing up the program. Then we will cover regulations. Under the heading of regulations, first off, we will have Senior Counsel Emily Gallagher from our legal division give you an update from our end. We will also welcome input from your end. I know that in Tamar in particular, you had a question about wanting to have some dialogue regarding how the advisory committee interacts with us regarding rulemaking. So we'll make sure we have time to discuss that. And then also, I believe that Cindy, I think that at one point you flagged that you might want to raise some issues related to the recently promulgated federal regulations from the Consumer Financial Protection Bureau. So to the extent the committee has any input on the impact of those recent federal regulations on your stakeholder groups, we welcome that input for consideration as well. And then after that, roundtable, any other topics that the committee members would like to raise, we are happy to have a more freewheeling discussion about additional topics that may have come to mind in preparation for today's meeting. And then last but not least, we will ensure that we preserve time at the end. I'll give us about 20 minutes at the end for public comment. Now for everyone in this meeting, whether it's a committee member or member of the department or public, if you are interested in making a comment when it is at the relevant agenda item, please use the reactions and raise hand function, and I will go around and make sure that I call on you so you have an opportunity to speak. So with that, I think we will move toward agenda item number 1, which is a program update. So Melinda, the floor is yours.
Hello, thank you, Suzanne. I'm Melinda, so I am in charge of the debt collector program. So as you all know, we started accepting applications on September 1st. We have started reviewing applications, though we are still in the very early age of our review process. Things will stay a little slow until we have fully hired and trained our teams. We expect to be at full capacity to review applications in early 2022. There are a couple things that we updated on our Q&A on the website that I want to bring up here about the application process. So first, just so everyone knows, NMLS defaults gives you a default status of pending incomplete. It does not mean your application is actually incomplete. It means we have not reviewed it to see if it's completed or not. So until we actually start the review process on your particular application, your status will stay as pending incomplete. We also will not invoice you for the licensing fee until we actually start the review process. And then the other thing is for the background check information and doing fingerprinting, we are not going to send out that information until, once again, we start actually reviewing your application. So that way we can make sure that we're requesting all the correct information. So all of that will happen once we start reviewing the particular application. Now, based on the volume that we're expecting to get on applications, our review process could take 1 or 2 years. So you may not hear from us for a very long time. We are sending out, we did send out already one notice for the people who already have their applications that were in by November, letting you know that yes, we received it. And we do plan to do that again in January, so at least people can have confirmation that we have received their applications. However, on that note, I was notified yesterday of a temporary slowdown in obtaining a new NMLS account. So anyone who is not already on NMLS and are trying to get an account, with the various year-end deadlines, they are experiencing an unprecedented volume of account requests. So applicants are hearing that instead of taking 2 to 3 days, it could take up to 10 days to get a new account set up. So we appreciate the predicament that this puts entities in who are trying to comply with the new requirement and have their license, have their application in by 12/31/21. So we would like to assure you that DFPI is aware of this issue, and we will not take any action against a debt collector solely on the basis of this temporary slowdown with NMLS. So we will continue to monitor the situation and will provide transparency throughout the process to the extent possible. So we do thank you for your patience on this. And I do also want to reiterate for everyone that the requirement is not that you are licensed by the end of the year, it's that you've applied for a license. So through our review process, and while we're working with you for these submittal issues with NMLS, you can continue doing business. So thank you, and I'll turn it back over to you, Suzanne.
Great, thank you, Melinda. So do any members of the committee have any questions or comments regarding our the licensing process and our program update? Raise your hand if so.
I have a question.
Yeah, go ahead, Scott.
Sure, thank you. Let me close this, sorry. So Melinda, thanks for that. So one of the things I think it might be important for the folks on the call and for industry to know is what happens for companies that if there is expected a 1 to 2 year review, what happens for brand new companies after the first of the year who are formed after the first of the year and submit their applications after the first of the year? Will no new companies be able to, in other words, will that same sort of, once you've applied, you get amnesty if you show that you were a brand new company, or will there be no new companies until licenses start to be issued?
No, We will, as new companies come in, they will be reviewed by a separate group or separate team. Basically, there'll be specific people assigned to do work on the new ones, because no, there is no basically safety zone for people who apply afterwards. So you are not allowed to do any debt collection until you're licensed if you apply afterwards. So any new companies that come into the business or addition to affiliates, like if you add an affiliate or something along that line, either way, you will need to apply and wait for us to review your application. But those applications will be reviewed separately.
Okay, I see Elizabeth and then Tamar.
If this question is more appropriate at the regulation or roundtable, please let me know. So I have a question regarding how the licensing will work to the extent any debt collection companies have either complaints against them by consumers through the DFPI's complaint database, or ongoing enforcement actions by other states or the CFPB. Will that be taken into consideration in terms of providing the license? Will the license be given pending that, or do we not know yet?
That will be considered. So each one will be handled on a case-by-case basis. We will consult our enforcement team and our legal team to determine whether or not the seriousness or what we're looking at, how, if it meets the requirements or does not for the licensing. So it will be on a case-by-case basis, but part of our review process is to look at complaints and to look at any enforcement actions. I think it was Tamar, you were.
Yeah, thanks, Melinda. A question that's come up in discussions I've had with folks at my company, some other companies, and with RMAI leadership as well, has been, while a license application is pending, can we just not include the license number on communications? And or would it be appropriate for a company to just write license application pending? You know, there's several ways to go about it, but I know that there's a concern about being sued if you don't put a license number down. Kind of, what are your thoughts on that, Melinda?
You will not have a license number until we actually grant you a license, and we will be providing license numbers, and I can't remember the format, how many digits it's going to be. If for some reason your people would like to know how many digits because they want to start working on forms, you can email me and I can tell them the convention. But what I'm recommending is that, yes, they put the license number, or not the license number, so DFPI number, and then put pending is your, it's not required, because obviously the law says license number, and you're not going to have a license number until we give that to you. But yes, for compliance reasons, I understand that it's difficult to continuously change your forms.
Yeah.
So if they want to get it set up now, they can use pending instead of an actual number.
Pending, or leave it blank altogether until the license number is provided. Would that be acceptable as well?
Yes. So we will provide a license number, and we have the number convention, so they'll know how many digits or space wise. I think it's 9 spaces, but could be 10.
Okay. Thank you so much.
Yeah.
I see a hand up from a member of the public. I did want to remind folks that we are going to take public comment at the end. I'm inclined, I'm facilitator's privilege here, I'm inclined to say if a member of the public has a discrete question on one of the topics we're discussing, would you mind just putting it in the chat, and I'm happy to read it and address it to the committee members. And with that, I will move on to Cindy.
Hi, thank you, Suzanne. I was just trying to find out if there were any earlier preliminary numbers as to how many applications have been received thus far.
We have received approximately 600 that are actively in the system. I cannot give you a, due to the backlog, I don't have a good estimate of what all is there.
And just a follow-up question to that, Melinda, based on preliminary review, is there any feedback to provide to industry or the membership regarding any top 5, or issues that you're seeing with the application process, or additional clarity on what you have reviewed thus far?
No, in general, they're actually coming in pretty good. I think the only confusion we have that would need some clarity that we're reaching out to is affiliates. So we have some companies that want to be grouped as an affiliates, and then we have some that are affiliated with each other that want individual licenses, but they list their affiliates. So there is we're reaching out to get some clarification on that, but in general, everyone's doing a really good job at submitting their applications. I will say that a lot of the questions that we get prior to submitting is, I'm not sure about this, or some of the documents they have to submit. I wouldn't be overly concerned. That's why we do the review process. So if we have questions, we will reach out to you. We will get the clarification that we need, and we will follow up with any concerns on who needs to have the background check or anything like that. We will work that out during the review process.
Before I get to Elizabeth, I see a few questions that have been dropped in the chat from members of the public. Thank you for that. The question from Richard Whitkin regarding HOA dues, I think that's probably more one for the regulatory. So I'm gonna table that one until we get to regulatory. I see a question though from Jeff Doherty about where should the license numbers be posted on each activity, on each material.
Oh, yeah. Sorry, I was reading the question as you were doing. I'd have to actually go back and reference the law on that, and unfortunately I do not have that open. But as far as, okay, I'm still reading, and this is about the, don't have the answer to that. Yes. So then as far as when you need to have it on, we will provide it. We'll provide it to you, the licensing. Once we approve your license, you get your license number. And then we would expect that you would be able to have that in place within the next 90 days. So we do encourage that, as I said, that you start working on your templates so that you know how they're going to be set up, and that all you have to do is drop the number in, and that it would be ready to go, almost immediately.
Okay, before turning back to the chat, I do see Elizabeth's hand up. So Elizabeth, you're next. But you're muted. There you go.
Yeah, it had to happen once. To the extent there is a debt collector who has not submitted an application, but is saying on their documentation, license number pending, can you provide, would you prefer advocates or consumers to report that through the complaint line? Or is that sort of more important for you, that you would like it to come either from a committee member or directly to somebody else?
It can either way, it's going to get to me. So whether you put it through our inquiries box or you put it in through our complaint, it will come to me. And we are looking into how the verification of that, and we have not determined how consumers would actually be able to verify with us yet if something is pending.
Okay, I'm going to turn back to questions that are being dropped in the chat. A question from Jay Brown about the typical turnaround time for email inquiries.
It really gets down to, I guess, the complexity of the inquiry. So it usually takes us 3 to 4 days to get back to people. But if you're asking us a more, I guess, complex question, it could take longer. And I do want to remind people, we cannot give you legal advice. So we really cannot say you need a license or you don't need a license. The only thing we can do is try to point you in the right direction so that you can provide you a place to look so you can assess yourself or have your own legal team assess whether you need a license. So in a lot of cases, if you're asking a license question about NMLS or something along that, we usually get back pretty quick. I know that it took us a few days to investigate what this delay was in NMLS. So I know people were waiting to find out how we were going to handle that. And we're still, I just confirmed with NMLS today how that's working and what we can do about it. So there have been some delays like that, but in most cases, we do try to get back to you within 3 to 4 days.
The team tracks every request. So, if a couple of days have gone by and haven't gotten a response yet, we may just need a little more time. But our team is working around the clock to respond to all the queries.
Yes.
A lot of them are coming in.
We've had more than 400 inquiries, separate inquiries that have included over 600 emails. And that's only been in the last couple months. So that we've been accepting inquiries. So there is a very large volume of them.
Okay, and then I also see a question from Jan Steger about guidance to industry members about what to put on communications prior to having a license number. I think we've talked about that a little bit already, but we can take it back and see if there's something else that we need to add to our Q&A or other matters that we may be able to speak to in updated communications. But thank you for flagging the disclosure issues. We appreciate that. We'll take that back. Any other questions about program updates before we turn over to regulations? All right, hearing none, we will move into our discussion about regulations. So to provide a department update, I will turn it over to Senior Counsel Emily Gallagher.
So there are 2 regulations packages right now related to the DCLA, and the first package, which provides the instructions for filing an application, is with OAL, the Office of Administrative Law, and we anticipate it will be approved and the regulations will be effective before the end of the year. For the second regulations package, it's in the very early stages. So in August, we circulated a pre-notice invitation for comments in which we solicited feedback about what regulations related to the scope of the DCLA, the annual report requirements, and the bond amounts should look like. And there is no regulatory text yet. So we're just in the very early pre-notice stages of this regulation project. We received comments in response to that pre-notice invitation list of questions from industry and consumer groups, as well as other members of the public. And all of these comments are public and available on our website. So I'd like to walk you through the questions we asked and a brief summary of the responses we received. So it's going to be a very brief summary of the responses. Again, that's because they are available on our website and we're still pre-notice. First off, we asked whether the terms in the DCLA and Financial Code section 100,002, such as debt collection, person, consumer credit transaction, etc., need clarification. And we received comments asking that we clarify whether the collection of various certain types of debt require a license and whether debt not yet in default would qualify. And we also received comments asking for clarity about certain practices of debt buyers. We specifically asked about the definition of debt collector, which is, and I'm going to quote this, any person who in the ordinary course of business regularly on behalf of that person or others engages in debt collection. And we asked whether we should clarify the terms, the word regularly and or the term in the ordinary course of business. And we received comments suggesting that we not further define these terms, and also comments suggesting that we call out certain businesses as specifically not covered by these terms. So we also asked whether a separate but similar term, this one in Financial Code section 100,001, should be clarified. And I'm going to quote one more time because it's specific. This section states that, quote, no person shall engage in the business of debt collection in this state without first obtaining a license pursuant to this division. And we asked whether, quote, engaged in the business requires clarification. Comments on this topic focused again mainly on specific business models and whether they should be designated by regulation as not in the business of debt collection. There were suggestions for establishing revenue or profit proportion thresholds for determining whether someone, an entity was in the business, as well as arguments against further defining this phrase at all. So we also asked whether the exemptions specified in the DCLA need further clarification. So these are the exemptions from licensure. Comments sought clarification as to whether the exemptions apply to subsidiaries and affiliates of the listed entities and whether all transactions by those entities are exempt. We asked whether the DFPI's authority to enforce the Rosenthal Fair Debt Collection Practices Act and the Fair Debt Buying Practices Act is clear. And we had a mix of responses, some saying it is clear and others suggesting we not interpret this enforcement authority to extend to, again, specific certain entities or types of business. We also asked whether the term due or owing, again, that's a quote, as used in the DCLA's definition of debtor is clear. And we had some comments stating it's clear and others stating it isn't clear whether it includes debt that is not yet delinquent. So moving on from the scope questions, we asked about whether the terms specifying what should be included in annual reports that are required of licensees need clarification and whether we should require anything additional because the statute appears to give us the authority to ask for additional information in annual reports. And we only had a handful of comments on this, asking what certain terms mean, and only a few comments actually suggested definitions of these terms. We also asked whether we should require higher bond amounts, and if so, how to determine those amounts. And we again had comments arguing both for and against higher bond amounts, as well as suggestions for how to determine those amounts based on models mostly from other states. And lastly, we asked for any other suggestions for regulations related to the DCLA. And we did receive some standalone suggestions, but most of the suggestions we received in response to this final question were actually related to other parts of the regulation or of the potential future regulation questions that we that I've already mentioned and that we asked earlier. So To close, I'll say we hope to have a first draft of regulatory text on this second rulemaking package out in the first quarter of 2022. So we expect there will be another pre-notice invitation to comment on that text before we file with OAL and commence the more formal rulemaking comment period. But please do not feel you need to wait for that invitation to make suggestions. We are happy to hear from you. You're welcome to provide me here, all of us, with your thoughts, as well as via email at any time, because we have not yet filed with OAL. There will be a draft text out first quarter, and you're welcome to provide comments or ideas for that text now before that time. So with that, I think I'll stop and turn it back over to Suzanne to field questions or call on people for questions.
Great, thank you, Emily. Yeah, so to her point, the timing of today's committees, in fact, it's well timed, because if there are any additional items that were not flagged in a comment, anything that the members of the committee want us to consider, we do welcome your input now. So please do raise your hand if there was anything that you wanted to highlight, anything that's a priority for your organization or industry segment. We're happy to take those comments now. Elizabeth.
Hi. So I know you can't comment on the regs and that, but I would just like to once again highlight the importance of including the back rental debt as included in the definition of debt, because we are already seeing multiple violations of the protections that are being provided both by the state and locally to tenants. And so we think it's a very, very important thing for the DFPI to consider, including back rent debt as a debt that the DFPI can enforce and that needs to be licensed so that there can be some enforcement action. Consumers and consumer advocacy groups are also very concerned about the bail industry trying to escape enforcement of consumer protection laws when they issue consumer financing contracts. So it is our hope that the DFPI very much takes into consideration that the bail industry, when they start providing consumer products, that the DFPI can enforce, and that when those bail contracts get collected on either by the bail company or a debt collector, that those collections should be licensed under the DCLA. And then I also just want to maybe, I'll save the stories for the roundtable. So those are just two things right off the top that I just want to, again, really encourage the DFPI to look into in terms of protecting consumers in California. Thank you.
Great, thank you for that, Elizabeth. Any other comments from the rest of the committee on regulations, potential regulatory matters that we should consider? Elizabeth?
I mean, I was trying to give other people space, but I'm happy to take it all up. So the other thing that I think that we really want to encourage the DFPI to think about is the bond requirements and the reasons behind that, because especially given that there's already 600 applications for licenses, I'm sure all of those 600 companies have different sizes, different amounts of collection. And we have provided information from other states that we think is very strong in terms of when small states are using a tiered bond or a tiered system, considering California is much larger and the licensing load is much larger, that the bond requirement should be increased and at the very least tied those increases to either and or the total number of debt collection cases that are either being litigated and or the number of the income that is being generated through the collection by the company. So if a company is not filing lawsuits, but they are collecting, the amount of total debt they're collecting and not just receiving, right? So if they have a portfolio of X, but they're only receiving Y, you can look at the size of the portfolio because those are the people that are being contacted by debt collectors. And hopefully everyone is complying with the law, but we know that a lot of people don't. And so those tiers will help the DFPI provide some protection for consumers who suffer harms from debt collection abuses, but may not be able to obtain, get a lawsuit filed because of their income. The bond will actually assist consumers, just like with the CSLB bonds, to recover some of that loss.
Sorry, before we move on, to make sure I fully understand your comment, can you say again what you mean when you said income and you distinguished they might have different kinds of income?
Yeah, so and maybe someone from the industry can also sort of explain how the portfolios work. But when there is a purchase of portfolios, there are a certain number of accounts that add up to a certain amount of money that could theoretically be collected. So that could be used as a tier. So if you have over X, then you fall into this bond. But the DFPI can also consider the amount that's actually collected, because if you've got a large portfolio, but you're actually getting only a certain, a small number of payments, versus you have a small portfolio, but you're getting a large amount of payments. We in the consumer industry see that those two groups could actually have the same higher bond, because it's a matter of how many consumers are being impacted by the collection efforts when those collection efforts go awry. Does that help?
Yeah, it does. Thank you.
Okay, I see Scott and then Cindy.
Sure. So Elizabeth, just to sort of follow up on your question about the bond amount being tied to litigation cases, I'm kind of interested in what you mean by a litigated case. So in other words, if a consumer is represented by counsel, right, and files suit, either files suit and then draws a cross complaint on the debt obligation, like let's say it's a product case, right, and they retain counsel on a lemon law, for a car or a product or something like that, right? But the account's in default and the bank files a cross complaint. Would that be something that you would count towards that as a litigated case in the bond requirement?
Yeah, I mean, I think maybe to just simplify it is any case, whether it's a complaint or a cross complaint that seeks to collect a debt.
Whether they're represented by counsel or not.
Absolutely, because whether they're represented or not, I'm just to clarify, are you making the qualification about the represented by counsel because you think that if they're represented, they're more likely to get damages, or because
no? Because right now, at least the Ninth Circuit has said that communications between counsel are not subject to the Fair Debt Collection Practices Act. So you don't have to give if our clients, for example, were involved in litigation and you and I represented our clients,
mm-hmm.
I wouldn't have to give a mini Miranda to you, for example, and then certainly I couldn't even communicate with your client because they're represented. So the Ninth Circuit has said that those communications are not subject to the FDCPA. So and this maybe sort of drifts over into the question to the members of the DFPI, how do we count? How would one count? And are we intending to regulate communications between counsel?
I don't think the
as licensed activity.
So I don't think the bonding question necessarily falls within a violation of the FDCPA. I think the bonding activity is, if you want to seek a license, you have to pay this fee. So if you are regularly collecting debt, if you fall into the category of being covered and having to be licensed, it doesn't matter if I'm saying to you, you have violated the FDCPA, or your client, theoretically your client is a debt collector and has already been licensed. So they would be subject to the bond. And if they file that lawsuit to collect on the debt, that's part of what would cause, that is a litigated case. I don't think we're talking about specifically, does this violation mean a license or not?
Well, I'm trying to understand again, when you count litigated cases, and lawyers aren't exempt from the licensing requirement.
Right. So if a debt collector, which could be a lawyer, could be a company, files a lawsuit to collect a debt, our position is that counts towards a number of case filed to establish how much bond is required.
From the lawyer's standpoint, whether the consumer is represented by counsel or not, that's licensable. Okay. So is that something that the department agrees with, that communications between counsel are licensed activity?
I don't think that's what I'm saying.
Fair enough. But at least as between lawyers, because lawyers are not exempt, are communications between counsel like licensed activity?
Are you asking me or the DFPI?
I think I'm asking the department.
Okay.
I think we can take that back. I personally think I'm hearing a question about, assuming someone is doing licensable activity, what the bond requirements would be, and then a question about FDCPA compliance, or whether a particular situation is subject to the FDCPA. So there may be two different overlapping topics that are being or issues that are being raised here. So I mean, we can take that back, or if we want to have a follow-up, just to better make sure that we're understanding the perspective and the issue, we can do that.
Sure, because it goes to, since we're in the regulatory arena, still that section of our of our topics, it goes to essentially how you count, right? If you're only communicating with other lawyers, are you engaged in debt collection activity when the only thing you're ever doing is communicating with other counsel? Or does that matter as far as whether that's licensable activity or not, that you're only dealing with represented debtors? So do you count those kind of cases in determining whether you regularly engage in debt collection?
Okay, I hear that, and will include it in my notes about considerations for the rulemaking and feedback I'm hearing at this meeting.
Thanks, Emily.
That does make sense. I understand what you're saying.
Great, Cindy, and then Prasad.
Thank you, Suzanne. Just kind of listening to, some of the comments that were made. I think that this would be a good topic for us to table, for follow-up in one of our future meetings, and, explore what the bond is actually utilized for as it pertains to collections, because, there is a clear distinction between a contingency collection agency working on behalf of a current creditor and someone who purchases debt. So there's two different business models that are going on. And then you talk about violations of FDCPA or Rosenthal, typically those are going to be something that are going to be involved in an actual lawsuit against the licensed entity, sole and separate from a bond. In addition, I am actually very curious as well. Other states were mentioned that utilize a tier structure. I mean, I think if we want to, explore that, let's actually do the homework. Let's take a look at the other states that, you're referencing, in particular, Elizabeth, so that we can kind of compare what that looks like. Compare it to, what we're talking about here in implementation in the state of California. I've been in business for 33 years, and, typically a bond, is something that in essence is there to protect my client that I collect on behalf of, in the event that I don't remit funds to my client. So, in essence, all those years ago, that's the primary basis for the bond. There's a lot of litigation that happens within our industry for violations of, or presumed about violations of, statutes and so forth. But very infrequently are we talking about coverage within the bond and the scale and scope of what that's utilized for. So I really think that this would be, something for us to get some takeaways, circle back, on defining what its role is as it pertains to being licensed and, someone exercising a claim against a bond in the state of California.
Okay, thank you for that. Prasad, you are next.
This is a brief and just in response to the reports on what the comments were saying with respect to definitional questions in the regulation. And it sounded like they had a structure whereby some were saying, please make sure that a particular activity is not covered under this provision, or leave the provision as it is with the kind of open language. And I would suggest considering a kind of middle path so that it's not a pure common law regulation where you're essentially asking the courts to make it all up after the fact, but to along the lines that, for example, Elizabeth had suggested, say that certain kinds of debt are included. And if you list them in seriatim, that not only clarifies that some of these marginal cases are, might seem to be marginal cases, are included, but that it gives the courts guidance as to what are the types of debt that should be included when they are going to try to reason by analogy after the fact.
Okay, so I just want to, again, make sure that I'm clear on your comment. You're suggesting that we focus on clarifying types of debt and not types of debt collectors?
No, it's just wherever there is open textured language where this kind of a decision needs to be made, that you consider listing what you believe are typical examples that definitely fall under the statute.
Okay, I see. Yeah, I see. Thank you.
Great, thank you for that comment. Elizabeth?
So just to respond to Cindy in terms of the bond, so there have been several comments put in by consumer advocates that actually do specify which states we're referring to. So you can look at those, I think, on the DFPI website. And then those same comment letters also discuss the consumer's position as to who is to be the beneficiary of the bond. And so unlike your experience, our position is similar to the bonds that are available with contractors or real estate brokers, that the consumer has the ability to collect from that bond to the extent they're unable to recover damages another way. And while, yes, there are cases that are filed for FDCPA violations and things like that that allow damages, there are many consumers, especially lower income consumers, who do not have the wherewithal, either because of their age or something else, to file lawsuits. And so if they're able to collect something from the bond, that would be, I think, another way to support the DFPI's intention behind bonding and licensing these organizations.
Yes, and the link to that Mark Alseeker put into the chat is our page where you'll see all the information about rulemaking activities under the Debt Collection Licensing Act. Prasad, did you have another comment?
No, I just haven't.
Oh, hands up. Okay. Great. Any other? Oh, Mark, please go ahead.
Just a quick question here, and maybe this is better tabled from a bond perspective, but A, I'm unaware of bonds being utilized in states to the extent that you're suggesting, Elizabeth. And my understanding is that you needed a judgment in order to access that bond. So I'm not sure how that would take precedent over a consumer filing adverse litigation against a collection agency or a debt buyer. Typically, in my mind, it would settle out far before any situation where there wouldn't be funds to settle out or something of that nature. So I'm just, forgive me, I'm a little confused in regards to that. And I'm not an attorney, so.
Sure, and I think it depends. I think, like, for example, in the Contractor State Licensing Board is kind of a good model, I think. So there, the agency can bring an enforcement action, and you can, a consumer, and our position, our hope is that the DFPI, in establishing the regulations for the bond, will say, for example, if the DFPI is bringing an enforcement action against debt collector X, you can recover part of the bond through that enforcement action. So it doesn't have to be the consumer bringing the suit, but the DFPI, because they're requiring the bond, that it can be recovered by the consumer that way. But yes, a consumer can also recover the bond through filing the lawsuit to collect on the bond. The reverse also happens. Sometimes the bond company will file, will try to settle it out, unable to, and then they file an interpleader to get any interested consumers sort of on notice. So it doesn't have to come from the consumer themselves, the lawsuit. It could come from the surety company filing the lawsuit saying, these are all the people who have requested payment. We don't know how to divvy it up. You go ahead and figure it out, court. But just to clarify that bond amount is not just for the benefit of, for example, the DFPI, or in Cindy's case, her client. It's also for the benefit of the consumer. I hope that helps.
Okay, thank you for that. And yes, I see the entry into the chat again from Richard about commenting on whether collection of HOA dues requires licensure. So we appreciate the feedback. These are the kinds of questions that a legal division is considering right now in terms of the scope. So if you have been submitting questions to us via email, or if you have filed a comment letter to us in response to our invitation to comment, just know that we hear you, we have that information, and we are going through these queries and taking them into consideration as we determine where we may need to further clarify the scope and application of the law. So do appreciate that. We just not at this point able to comment today in response to that direct question, but we are taking this feedback into consideration very seriously. And so I see a question about, has there been discussion on the comment from Duke University, which is posted online? I am not aware of the contents of that particular comment letter specifically. I don't know, Emily, do you recall that one?
I don't recall it off the top of my head. When you say online, if you could respond in the chat, do you mean online that we've posted it on our website?
Yes.
Yes. Okay.
Yes, it's posted under the comments on second modifications to proposed text.
Okay, so second modifications to proposed text, that is that would be the first rulemaking then. The one that I said is with OAL, and that we expect to be adopted by the end of the year. So there should be responses to public comments also on our website. So I didn't handle that rulemaking, so I can't say for sure where it is, but that's what I expect, is that we have a comment, or we have a reason why we didn't need to comment to respond to that comment.
Yeah, and just for some extra clarity for the group, there were, for technical reasons on our end, there were modified text was published, and we had to jump through some additional hoops that kind of came up. But we know that there are people who have commented multiple times and raised additional issues that are just, because of our time constraints, because of the statutory deadline, simply we could not fit them into the first rulemaking. But even if it didn't fit into the first rulemaking, which really is kind of just trying to lay out the nuts and bolts of the application process, we do continue to consider all of the feedback that we have received from commenters. And just folks, just to manage expectations, folks should expect there are going to be several rulemaking packages in this space. This is going to be an iterative process. We are learning, and we will adapt and improve as we build out this program, which is the largest program by a mile that this department has had to build out in many, 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 many years. So just know that even if you have not seen that reflected yet or publicly addressed, just know that we are still working through it and we are in process. Jennifer, would you like to say something?
Yeah, I just wanted to clarify, because we are talking about a couple of different rulemakings here. So to the extent that Duke University comment was submitted in response to the pending first rulemaking that is currently with OAL, a comment will be included in our final statement of reasons, which is not yet public. But once once OAL completes its process, then that will become a public document. But as of, so it's like, yes, it's been addressed, it's just not yet public, it's with OAL. So I just want to make that clarifying remark.
Thank you, Jennifer. Yep.
Great, thank you, everyone. Any other questions? We are at 4:07. I am mindful of the time and want to ensure that we get to any other topics we wish to discuss today, and then provide some time for public comment. Did the committee members have anything else they wanted to discuss regarding our regulations? Or again, I know last time it was flagged that there were federal changes. I don't know if the impact of those are being felt such that you want to raise anything for us to consider during this committee meeting, but please speak up if so. Tamara.
Thanks, Suzanne. So a couple of comments. First of all, and I think I raised this at the last meeting, there's obviously a lot to talk about, and this is a complex industry, and as committee members, we have a lot, I think, to offer the DFPI. And I'd ask if we could consider meeting more frequently, maybe quarterly, so we're able to have more of these types of conversations and also provide our input before new rulemakings are started. So that's the first topic. The second issue, and Cindy might want to talk about this more because I know, she's very knowledgeable from the small business perspective, but yeah, the CPB rules just took effect 2 weeks ago, and they have created an absolute sea change for our industry. It's a huge undertaking for companies, big, medium, and small, and it's hard. It's tough because it's changing literally every aspect of the way debt collectors communicate with consumers, disclosures, data, everything you could think of. And so, it's an enormous undertaking. We support the changes because it's good to have that national standardization, but it's a difficult challenge for our industry. So it's definitely something for the DFPI to be aware of. And of course, as committee members, we're happy to provide, any additional information or detail. Most of us probably know the rules in and out by this time and can recite them in our sleep, but it's definitely an important topic, I think, to discuss for sure.
All right, thank you for that. We hear, the committee, the statute, I think, requires us to meet a minimum of twice a year. We understand the committee wants to meet more frequently. We will see what's doable. I think in part, we wanted to wait until the new commissioner came on board to have this second meeting because we felt it was important for you to meet her and for her to hear your perspective. We will take it back and see what's doable from a logistics perspective. As you can imagine, scheduling these is not easy, but we hear you on that, and we'll take it back and see what we think. Once the law is fully in effect and it's January 1, now we can take a look at what the proper meeting cadence is, but we definitely hear you on that and appreciate, the note about how there is, now new compliance, efforts underway due to these new federal CFPB regulations, which regulate various aspects of the methods and timing around communicating to consumers. So we can definitely have more dialogue about that, and certainly we'll be eager to hear how the compliance with the new regulations going forward is going for those of you who are impacted. Cindy.
Just thank you, Suzanne. Just maybe to, I guess cap off on, some of the Reg F. I mean, this is the largest overhaul for our industry that we have seen since 1977. The rules that were instituted by the CFPB in text are well over 1,000 pages and have taken industry quite some time to be able to dissect and then, of course, get ready for implementation. But we're there. And, believe it or not, there are some, extremely positive takeaways for industry with this, and the way that we're able to communicate with consumers. Clarity is now before us in a standardized way that we did not have before in our industry. I think, obviously as a small business owner, navigating this has been extremely challenging. And I am not alone. I represent in the California Association, the majority of our membership are business owners with less than 20 employees. And when you have to overhaul communication with consumers and the model validation notice, and then working with your clients, because the education is not just with our staff, it is with every single client that we work on behalf of in this process. And, here in California, we not only have licensure, but coming up this next year, we have three new collection laws that are going to be going on the books that are also specific to certain types of debt, which offer our membership an additional challenge to comply with, whether it's, student loan industry or, the medical industry, or a general one with regards to debt collection in general, and, additional disclosures that we have to provide now on our model notice come July of this next year. There's a lot of overlap with that in addition to the Reg F. And so, obviously one thing that we are mindful of and hope, in this rulemaking process in working with the DFPI is that we don't add additional confusion to consumers with all of this additional overlay that's happening, whether it's a type of debt or a rule or a regulation that's coming into play, because the CFPB has really done a lot of work in order to standardize for industry some of these things. So, with that, that's kind of my comments on Reg F.
Great, that is very helpful. Thank you, Cindy. Turning back to the chat, I see a question about whether we would consider allowing, I'm assuming that's private right of action for debt collectors that do not get licensed. Then we would not, well, private right of action is something that an individual brings. I would say, for unlicensed activity, once the statute is in effect, unlicensed activity is for those who are subject to the law is a violation. So we would use our enforcement resources appropriately. I hope that's responsive. And then a question again about NMLS delay. How should companies that are delayed bring the delay to our attention? Melinda, you take that one.
Yeah, I was just typing in a response, but I'll go ahead and do it verbally. So the NMLS team will provide me with a list of who's in process. So if you have started the process, I will know. And based on the backlog that they're talking about, the delay should only be a couple weeks. If you have a further delay because you're missing information, or something beyond that, then you should reach out to us through our inquiries email, dcla.inquiries@dfip.ca.gov. You should reach out to us, and we will look at those cases on a case-by-case basis if the delay is going to be longer than that. And in a lot of cases, I'm getting consultants who ask me questions or lawyers who ask me questions. And I will need to actually know who the entities are, because I can't assess the situation without knowing, all the facts about it. And if we do set up something with them, it will have to be directly with them. So I hope that answers the question. If there's anything.
Thank you. And Melinda, if you could put the inquiries email address in the chat again, that would be great.
Yes.
Being mindful of the time, again, thank you, everyone. We are capturing the questions and comments that are in the chat. So if we do not get a chance to directly answer your question in the brief time that we have left, just know that we are capturing them, and welcome a follow-up if you would like to email us that question at the inquiries address that Melinda is going to put in the chat. We invite you to do so, because again, we are taking them in, we are tracking them, and I'm trying to respond to every query we get as quickly as possible. Again, I did promise that I would allow an opportunity for public comment. We have 13 minutes left. So if any member of the public wishes to provide a brief comment, 30 seconds to a minute, please, could you raise your hand, and I will be happy to call on you. Okay, Mark, you're up.
Hi, can you hear me okay?
Yes, sir.
Okay. I wanted to see if there was any way you guys could work on changing the rules around telephone debt collection. The rules regarding an auto dialer have been changed recently, and it's become a problem. Some other states have completely revamped their definition of an auto dialer, and I think it would be helpful if the commission could do the same. Thank you.
Okay, thank you for your comment. And again, that feel free, if there's any more information or context about the auto dialer issue, welcome that submitted to the inquiries email as well, so that we can take it into more detailed consideration. Any other public comment? And yes, Anastasia, thank you. I do see your comment in the chat about the DCLA licensing and the higher education context. So we will take that back as another question for consideration in clarifying the potential scope of the law. Any other public comment before we close? We still have about 10 minutes. All right, if not, are there any final remarks from any members of the committee? All right, if not, oh, Scott, do you have something?
I was say I would echo the comment that if we could meet quarterly, I think it would be beneficial both for certainly for the members of the committee and hopefully for the other members of the folks that are on the call.
All right, no, thank you for that. We will take that back to the commissioner and discuss what we think we can commit to. All right. Well, if there are no more comments, or Cindy, do you have a comment?
I just wanted to say thank you for your time and welcome to the commissioner. It's happy to have you on call today, and we look forward to working with you and as we get through this process, and anxious to hear how the licensure process is coming along with your team, Melinda, and thank you for all your hard work.
Great.
Yes, thank you. Thank you so much. We're all on a wild adventure together, but we will get there. And again, always feel free to reach out and give us your feedback, give us your questions, give us your input. We do take it very seriously. And as I said, we really view this as a partnership, an iterative process, and do appreciate the members of the advisory committee and members of the public who join and provide comments as well, because we want to get this right and be as smart about it as we possibly can. So more information is better.
Thanks so much, Suzanne.
Thanks,
All
Suzanne.
right. Thank you very much, everyone. Have a wonderful holiday season, and we'll be in touch.
You will. Thank you, everyone.